Good morning to everybody. I open meeting number 19 of the 52nd session of the Committee on Economic, Social and Cultural Rights. My name is Zdzisław Kędzia. I'm chairing this committee for the time being, and today we will consider the second periodic report submitted by the government of the Czech Republic. Let me extend my cordial welcome, first of all, to the delegation of the Czech Republic, headed by Madam Andrea Barszova, head of the delegation who represents the office of the government. Madam Barszova is accompanied by Her Excellency Madam Katerina Sekwencova, who is the permanent representative of the Czech Republic to the United Nations organizations in Geneva. Our cordial welcome, and we wish you a nice stay here. I would like also to welcome the other members of the delegation of the Czech Republic, in particular those who have traveled from the Golden Prague, and we also extend our good wishes to all of you. Let me also welcome all the observers representing the civil society, non-governmental organizations, and I would like to extend my special welcome to the group of students who are students of our dear colleague and friend, Professor Skrever, and these are students from who attend the program of international law at the University of Leiden. Thanks to their presence, we can reach out not only to the Netherlands, but to many countries, since, as I have been told, this program at the Leiden University is attended by students from more than 20 countries. So, welcome to all of you. Allow me, please, to briefly outline the proceedings today. We will begin with an opening statement by the head of the delegation, after which I will give the floor to committee's rapporteur on the Czech Republic, Ms. Kong Jun. Following on her introductory remarks, we will enter the main part of the dialogue between the delegation of the Czech Republic and the committee. In accordance with our preliminary agreement with the delegation and with a view to making our dialogue as effective, as efficient and as substantive as possible, the dialogue will be conducted under 4 thematic clusters based on our covenant. At the beginning of the exchange, the committee members and the delegation, I will ask my colleagues to raise questions on the first cluster, this Article 1 to 5, and they deal with some general matters, including the system of protection of human rights in the state party, including the legal standing of the covenant within the system of law of the state party. These first questions relate usually to the question to the principle of equality and non-discrimination in various aspects, and under this first cluster, we tend also to raise some general issues related to the implementation of the covenant, including, for example, the participation of state parties in international cooperation. Then we move to, after the round of questions under the first cluster, we will immediately move to questions under the second cluster. The second cluster is related to Articles 6 to 9. These are labor rights, trade union rights, and all the issues under the chapeau of the right to social security. After having finished questions under these two clusters, we will interrupt the meeting for some 10-15 minutes, depending on the needs of the delegation, in order to give the delegation the opportunity to organize responses to these first two clusters. And then we will continue, but responses will be provided by delegation on the cluster-by-cluster basis. Why it is important? Because at the end of each cluster, we will have a relatively short session of follow-up questions and answers. This would make this dialogue even more direct and more interactive, and I think this would be helpful for both the delegation and the members of the committee. At 12:30, as we agreed with Madam Head of the Delegation, at 12:30 we will again stop the responses in this case, and the purpose of this measure would be to offer the members of the committee the opportunity to come up with questions under clusters 3 and 4. This will be done in order to also give the delegation the opportunity to spoil their lunch and organize the responses for the afternoon. This is what we are planning as far as the organization of our work is concerned. At the end of the exchange, we will have concluding remarks by the head of the delegation and some first impressions presented by the rapporteur for the Czech Republic. This is our overall framework. Now, before moving to asking the head of the delegation to present her introductory remarks, I would like to make a special, let's say, intervention. Namely, and please allow me, because I didn't manage to do it yesterday, and yesterday we extended the meeting a little bit. We had to review yesterday the report submitted by the People's Republic of China. It took a lot of time, and we exceeded the time scheduled for our work, and I would like to thank the interpreters for their patience, kind cooperation, and acceptance of this exceptional measure which we applied yesterday. Thank you very much to all of you. Now, let me turn to the head of the delegation, to Ms. Andrea Barszova, and ask her to present her introductory remarks.
Thank you very much for giving me the floor. Dear Mr. Chairman, distinguished committee members, as already mentioned by the chair, my name is Andrea Barszova, and I am the head of the Human Rights Department at the Office of the Government of the Czech Republic. I would also like to introduce the other members of the delegation. Sitting next to me is Her Excellency Ms. Kateřina Sekvencová, the ambassador and the permanent representative of the Czech Republic to the United Nations Office and other international organizations in Geneva. Further, my colleague from the Government Office, Mr. Jakub Machačka, head of the Secretariat of the Government Council for Human Rights. Other members of the delegations are Mr. Josef Vymazal, Deputy Minister of Health, Ms. Daniela Grab-Millerová, Head of the Department of European Affairs at the Ministry of Regional Development, Mr. Pavel Janeček, Head of the International Cooperation Unit of the Ministry of Labour and Social Affairs, Ms. Pavla Růžková from the Department of Education of the Ministry of Education, Youth and Sports, Mr. Dominik Korčák from the International Cooperation Department of the Ministry of Justice, Mr. Pavel Štěpáník from the Department of Security Policy of the Ministry of Interior, and finally, Mr. Viktor Velek, First Secretary from the Permanent Mission. First, I would like to thank the committee for the opportunity to discuss the second periodic report of the Czech Republic concerning the implementation of the International Covenant on Economic, Social and Cultural Rights as well as the latest developments and issues raised in the list of issues. We are looking forward to engaging in an open and constructive dialogue with the committee. An issue of great importance for the protection of human rights was the adoption of the Anti-Discrimination Act in 2009. This act is designed to strengthen the protection against discrimination in all major areas of social life, like employment, social protection, healthcare, housing, and education. The Act defines direct and indirect discrimination, harassment, persecution, instruction to discriminate, and instigation to discriminate, as well as permissible cases of different treatment objectively justified by a legitimate aim and pursued by reasonable and necessary means. The protection against discrimination is provided in two ways. Victims of discrimination can apply to the competent state inspection authorities who may investigate violations of equal treatment of persons and impose fine. The second wave is a court action against discrimination where the victim can request that the discrimination be ceased, the consequences of discriminatory action remedied, and reasonable satisfaction granted. The Czech Republic supports equal opportunities for women and men by annually adopting the government's priorities and actions to achieve equal opportunities for women and men. The Government Council for Equal Opportunities for Women and Men, which includes representatives of the civil society and academia, is closely involved in designing and monitoring these measures. The new government is focusing mainly on the reconciliation of the working, private and family life of women and men, as well as increase in the proportion of women in decision-making positions and eliminating the gender pay gap and domestic violence. Awareness-raising campaigns addressing gender stereotypes and domestic violence are planned for the near future. The Czech Republic is focusing on maintaining the quality of its human rights protection system. Independent courts are protecting the human rights and freedoms of individuals, including economic, social, and cultural rights. The mandate of the Ombudsperson is gradually being extended to encompass new human rights portfolios as the National Equality and Anti-Discrimination Body, as already mentioned, or the protection of the rights of foreigners during detention and expulsion procedures. In this manner, the Ombudsperson exercises many of the functions of the National Human Rights Institution according to Paris principles, although not registered as such. Currently, the mandate of the Ombudsperson is being revised to encompass all those functions and to be able to apply for accreditation as the National Institution for the Promotion and Protection of Human Rights. Other human rights protection bodies mentioned in the report, such as the government human rights advisory bodies, continue to deal with human rights issues. They have also collaborated on the periodic report. The present government has replaced the Commissioner for Human Rights with the Minister for Human Rights and Equal Opportunities, who is a member of the government and can elevate the status of the human rights agenda within the government. In the field of economic and social rights, the government's main goal is the social inclusion of every person. The social inclusion strategy for the period 2014-2020 is the general policy document for the fight against poverty and social exclusion with specific goals to reduce poverty with the help of the European Union structural funds. The strategy is being elaborated through specific strategies on the promotion of the human rights of various vulnerable groups. I will mention some of them. Children are the target group of the 2012 national strategy entitled The Right to Childhood. The strategy is accompanied by detailed action plans which are designed to meet the obligations arising from the UN Convention on the Rights of the Child in full. The Czech Republic also adopted the new National Action Plan promoting positive aging for the period 2013 to 2017, which explicitly emphasizes the protection of human rights of older persons as one of its principles. The two main strategic goals are to improve public awareness concerning the needs of older persons and to provide them with protection against all forms of discrimination, abuse and neglect. The National Action Plan for Equal Opportunities for Persons with Disabilities for the period 2011-2014 implements the principles of the Convention on the Rights of Persons with Disabilities, mainly regarding accessibility and equal opportunities. The plan is now being revised. The concept of the prevention and solution of homelessness till 2020 sees the situation of the homeless from a complex perspective. A major task for the Czech Republic is the integration of Roma minority. The strategy for Roma integration for the period 2010-2013, which is now being revised for the period up to 2020, and the strategy for combating social exclusion focus on the integration of the Roma minority and other persons threatened by social exclusion in all areas of social life. In addition to social inclusion, the strategy of Roma integration also aims to promote the rights and interests of the Roma, both as individuals and as a national minority. The Czech Republic is preparing a new complex system of social housing with appropriate legislation and practical measures to help municipalities provide adequate housing for their inhabitants. The government also supports social work program run by municipalities as NGOs, providing assistance for people in need in solving housing and other problems. The Agency for Social Inclusion offers municipalities assistance with the development of their own effective local housing and integration strategies. Due to economic crisis in the period 2011-2012, the Czech Republic introduced some austerity measures. The aim of these measures was to target social benefits better and to prevent their abuse so that more funds could be spent on people in need of assistance. The present government is now analysing the effects of those measures and will prepare changes. These changes will enable the administration to increase effectiveness of the social system as well as to avoid any social hardship, which also means to exercise better the rights set forth under the Covenant. One of them is the planned increase in the minimum wage to 40% of the average wage in the coming years. The full indexation of retirement pensions will be introduced in 2015. The health service system is subject to new laws governing the provision of health service with respect to modern standards of healthcare and medical methods, as well as rights of the patients, including those with disadvantages and disabilities. Free and informed consent is a general prerequisite for the provision of any service. Only in extreme cases of medical necessity, to save the patient's life or health, may the patient be hospitalized and necessary care provided without prior consent. The present government is continuing the process of the deinstitutionalization of the mental health care and residential social services, as well as reforms aimed at better accessibility of health care and financial sustainability of the healthcare system. The government is also focusing on the prevention of drug abuse among public, especially the youth, and is providing financial support to health and social services working with drug abusers and their families. The Czech Republic sees equal access to quality education system as the basis for the country's future development. Education is free of charge from the last year of preschool education up to tertiary education. Its affordability and accessibility to all persons is further supported by social scholarships. Special attention is being paid to pupils with special education needs, such as pupils with disabilities or pupils with social disadvantages, in particular the Roma. Legislative changes were implemented in order to decrease the high proportion of Roma children in special education. They follow a modern, individual approach to the integration of persons with special education needs by introducing supportive measures adapting to the environment in order to increase the individual achievement of every learner. Roma children with social disadvantages are supported in their schooling in kindergartens and preparatory classes and by pedagogical assistants who also assist children with disabilities to become integrated within the mainstream education. The ethnicity and number of children in each education program is being monitored so as to avoid any possible indirectly discriminatory impact. The results show that the proportion of Roma pupils educated within the special education system is decreasing. All measures are elaborated and discussed with relevant experts and stakeholders from the general public as well as being appropriately financed. Dear Mr. Chairman, dear committee members, I have tried to summarize the development of the situation of the Czech Republic over the past years and the core topics in the list of issues. The Czech delegation would be pleased to respond on these and any other issues when we take questions from the committee. I would like to conclude my remarks by reiterating the Czech Republic's firm commitment to upholding its obligation under the Covenant. Thank you very much for your attention.
Thank you very much, Madam Head of the Delegation, for your very instructive and very enlightening introductory remarks. You have addressed a number of issues, including the approach taken by the government to address the impact of the economic financial crisis on the area of economic, social, cultural rights, and I noted your reassurance that this impact should be kept under control and should be countered by special measures taken by the government. In this context, just I would like to refer also to the letter sent by the chairperson of this committee, Mr. Arianga Pillay, in 2012, in May 2012, a letter concerning the compatibility or the conditions for compatibility of austerity measures with the requirements of the Covenant with the economic, social, cultural rights. Thank you very much once again. And now I would like to ask my colleague, Madame Kong Jun, rapporteur for the Czech Republic, to present her introductory comments. Madame, the floor is yours.
谢谢主席. Thank you, Mr. Chairman. At the outset, let me extend a warm welcome to the delegation of the Czech Republic and thank the head of the delegation for her introductory statements. In her start statement, the head of the delegation gave us an overview of the achievements and the latest progress in the protection of economic, social, and cultural rights in Czech. I would also like to thank the government of Czech for the report and the reply to our list of issues. From these documents, our committee understands basically the implementation of the concluding observations of our committee with some positive and some in positive aspects and some in inefficiencies. According to your new situation and the implementation of the previous concluding observations, we are more interested in the following questions. First, the intention of the state party to access the optional protocol of our convention. Second, the application of the covenant in the state party's domestic law. Three, the application of accreditation of your public defender by ICC. Four, non-discrimination, including measures taken to prevent discrimination against Roma, persons with disabilities, refugees, and asylum seekers. Fifth, gender equality. Sixth, employment. Seventh, impact of austerity measures on social benefits. Eighth, domestic violence. Ninth, healthcare and mental health. 10th, segregation of education. 11, cultural rights for minorities. For the moment, I have only one question. In paragraph 15 of your reply to the list of issues, I quote, the strategy of crime prevention 2012-2015 also focus on the elimination of racially, nationally, and religiously motivated crimes. The goal of this strategy, apart from the prevention of racism and xenophobia, is to support the coexistence of the majority society with ethnic minorities and thus decrease the substitute motives of extremist attitudes and demonstration. Let me praise the State Party for using the word coexistence. According to a study conducted by Czech Institute in 2010 on the perception of coexistence of Romani and non-Romani population, those who believe that the perception is good in percentage has dropped constantly from 23% in 1999 to 10% in 2009, while the bad in percentage increased from 66% in 1999 to 85% in 2009. I would like to hear from the delegation your take on this study. We would like you to share with us what results you have achieved in preventing racially motivated crimes. Thank you.
Thank you very much, Madam Kong. Now I would like to move to the list of speakers, and I have now, for the time being, 6 names on this list. And the first speaker will be Mr. Atangana, and he will be followed by Mr. Dasgupta. Mr. Atangana, the floor is yours.
Merci, Monsieur le.
Thank you very much, Mr. Chairman. I would also like to welcome the Czech delegation. I think that today's dialogue should indeed be a fruitful one. My questions will focus primarily on the status of the covenant under our issue number 1 in the list of issues. Now, in your replies, you have given us some information to say that there are courts which have seen cases pertaining to the provisions of our covenant. Among these courts, you mention the Constitutional Court, the Supreme Court, and the Supreme Administrative Court. My question then is whether the other courts in the State Party wouldn't be concerned. Have they not ever had cause to refer to the covenant? Because you only mentioned these 3. I would also have a comment which stems from our previous concluding observations. This was the first subject of concern, and we said the committee regrets that full effect has not been given to the covenant in the courts of the State Party, and that the majority of rights enshrined in the covenant may not be tried by the domestic legal system, in particular the right to decent housing. But in the replies that I've just mentioned, among the decisions handed down by the Constitutional Court, there is indeed a case which concerns the right to dignified housing. So does that mean, or adequate housing, so does that mean your position has changed then, compared to what I've just read? I would like to hear more information from you on this matter. Thank you, Chairman.
Thank you very much, Mr. Atangana. Mr. Dasgupta will take the floor now, and he will be followed by Mr. Scriver.
Thank you, Mr. Chairman. I'd like to join my colleagues in extending a very warm welcome to the distinguished delegates of the Czech Republic. My question relates to Article 2, the obligations of international cooperation. According to information available to us, the Czech Republic has contributed only 0.12% of its gross national income as overseas development assistance. This, of course, is just a tiny fraction of the accepted international goal, the UN goal of 0.7% of GNI, and it's only a little above 1/3 of the agreed EU target of 0.33% to be achieved by next year, 2015. So my question is, can you tell us what the Czech Republic intends to do in order to live up more effectively to its international obligations in this area? Thank you.
Thank you. Mr. Dasgupta, after Mr. Scriver, Madam Sheen will take the floor. Mr. Scriver.
Thank you, Mr. Chair. Also from my side, a warm welcome to the Czech delegation. Women are in the lead, as we can see at the front stage, so no need for particular questions on the non-discrimination concerns. Could I first of all raise, indeed, like my colleague Mr. Atankana, the issue of the domestic application of the covenant? He raised already a couple of questions on court decisions. I noted that according to your 2002 constitution, international treaties can have priority over domestic legislation. So my question is, have there been any findings that the rights contained in our covenant are not in accordance with domestic legislation? And if so, does that mean that the domestic legislation has to be discarded, has to be amended? So have there been cases of a conflict between the contents of a provision of an international treaty, for example our covenant, and your own legislation? My second question relates to the status of the Office of the Public Defender of Human Rights. By the way, I find that a very inspiring term, Public Defender of Human Rights. I noted that sometimes he or she is also referred to as the Office of the Ombudsperson. I understood that no accreditation in accordance with the Paris Principles has been solicited for. So you do not aim to see this as a so-called national human rights institution in accordance with the Paris Principles, but we would like to hear something more on this, whether you intend to revise the mandate, the statute of this office, so as to meet in future the requirements of the Paris Principles of the United Nations for a national human rights institute. Lastly, my colleague Mr. Dasgupta raised already the issue of ODA, and that indeed 2015 is coming very close, and we still do hope that you meet the target set especially for countries of Central and Eastern Europe to meet halfway the 0.7% at 0.33. My question is whether, as to the contents of your official development assistance, you also take our human rights into account. To what extent, under ODA, you also perform programs aimed at the implementation of economic, social, cultural rights or human rights in general in recipient developing countries. Thank you.
Thank you very much, Mr. Scriver. And after Madam Sheen, the next speaker will be Mr. Sadi. Madam Sheen, the floor is yours.
Thank you, Mr. Chair, and good morning to the delegation from the Czech Republic. I listened attentively to the introductory statement by the head of delegation, although the statement was not distributed. So it's good to hear that you are taking steps to register with ICC for accreditation of your national human rights institution. And you said that the mandate is being revised. Because I had a question before whether your public defender is also covering the private sector. And if you are saying that you are currently in the process of revising the mandate, in what way, what was the area that was not in accordance with the Paris principle, for example? So could you give me more insight on that issue? And happy to hear that, you are taking that step. My question is regarding non-discrimination and gender equality. And first of all, thank you for this extensive statistics provided. And that is really helpful in understanding the situation. I know that you have law on anti-discrimination, and many of these statistics concerned violation of prohibition of discrimination in 2005. So I would not know the current situation, but when I looked at your statistics, I see, for example, there is no sexual harassment at all, and if there is no sexual harassment, I would be, of course, happy. But there must be some deficiencies in handling the law, whether people would not know how to file violations. I don't know, because as we know that all around the world there are sexual harassment. And also gender discrimination, despite of the real gender equal delegation that we see also in every countries. So in your 2009 Anti-Discrimination Act, how is discrimination defined? Because I presume that it covers all areas of discrimination, like discrimination against persons with disability, women, ethnic minority, etc. So you have all the separate definitions of discrimination. I know that you have a law, for example, regarding persons with disabilities. It includes reasonable accommodation, as you said in your introductory statement. So I would like to find out more about how this Anti-Discrimination Act is formulated and currently working. My last question is regarding gender equality, and in your replies, you said that you are not adopting any temporary special measures to accelerate gender equality, which is provided in the CEDAW Convention. And I would like to know why are you not applying this temporary special measure for enhancing gender equality? And I will ask, as the proper cluster of articles come, I'll ask other questions. Thank you very much.
Thank you very much, Madam Shin. I would like now to call on Mr. Sadi to take the floor, and the next speaker will be Madam Brash Gomez.
Thank you, Mr. Chairperson. I join my colleagues in extending a very warm welcome to the delegation. Madam Leader of the delegation, you highlighted the anti-discrimination legislation that you have. It's very interesting because this is the core element in the first cluster of issues that we're dealing with. I don't know if the coverage of this discrimination includes the what paragraph 2.2 of the covenant, which seems to be a broader basis for anti-discrimination, and if not, whether you intend to broaden the basis for discrimination to be covered and to be in harmony with the covenant. In other words, we would like to see anti-discrimination as wide and comprehensive as possible. More, even not less interesting, is what are the remedies? Many countries have anti-discrimination. I would like to know what sanctions are applied when discrimination occurs, and I would be interested if punitive sanctions can likewise be be applied, because it's not enough to have anti-discrimination if you don't have the tools to punish people who perpetrate that kind of violation. On the Roma, as you have about 200,000, I think, that's what I remember. Most parts of Europe have the Roma problem, and they all have action plans to integrate them, and yet few of them, if any, have succeeded. What are the obstacles in facing your country in integrating the Roma? I don't understand. Every country in Europe almost has similar problems, and I don't know what are the impediments in moving ahead and integrating that group of people. I noticed that you also have the Council for National Minorities, in view of the fact you have Hungarians, Croats, Hungarians and Germans. And so could you shed some more light how this council functions in practice? And my other point is, since you have in the governance system, you have regional government institutions, how is this regional application of the covenant? How is the covenant being respected and observed by the regions of the country, not only by the central government, but on a regional basis as well? The austerity measures introduced to you, we spoke a lot about it, and we all cautioned countries against it. We issued a statement and so on and so forth. But have you been able to measure the impact of austerity on the enjoyment of our rights? I would be very much interested in knowing what the results were. My last point, I promise, whether you have human rights education introduced, and by human rights education, I don't mean just human rights education in general, but human rights education according to the UN principle, UN treaties, because many countries say we have human rights education, but this following question is, is this human rights education in conformity with, for example, in our case, with the covenant? My last point on the ombudsman, I know you said your ombudsman meets the requirements of most of the Paris Formula principles. What prevents you from meeting all the principles? I mean, you're an advanced country, you're a sophisticated country, you're a strong country. I hate to see that you're setting the wrong example to countries which are less advanced, and yet they have been able to attain that objective. It's not such a big deal to observe the Paris principles. It's not such a hard thing to do. And I was wondering whether you're willing to move ahead in that direction. Thank you.
Thank you very much, Mr. Sadi. Now I turn to Madame Brash Gomez, and after her, I would ask our rapporteur whether she would like to come up with some questions.
Thank you, Chair. My life has been made very
So,
much
Madame
easier after all my colleagues. First of all, good morning and a very warm welcome to the delegation. Just a couple of follow-up on the issues my colleagues have already raised. Like my colleague Ms. Sheen, I would like to thank you for the extensive disaggregated statistics on an yearly basis. It really makes our life much easier. But it also gives us the possibility of more focused questions. So if I look at the anti-discrimination complaints to the Ombudsperson, I think it's well disaggregated by areas of discrimination. What I'm not able to assess here is the degree of compliance on the part of the state. So there are all these complaints that have been presented in terms of anti-discrimination. I would say the Ombudsperson, I would assume the Ombudsperson has made recommendations in relation to these complaints. Some of them may have moved to court. Some of them certainly gave rise to recommendations to various government departments. What has been the degree of compliance? What is your assessment of the degree of compliance? And generally speaking, state governments are not always happy with the recommendations of Ombudsperson. That's the way life is. We all have our roles to play. But I just wanted to check with you on what your assessment is on how far the state bodies have complied with these recommendations. In relation to the anti-discrimination law, I also, like my colleagues, have not found a clear statement of what the anti-discrimination law really includes as grounds for discrimination. And I think, like many other countries, you have specific discrimination provisions in all your different laws on employment, on education. And that, in our experience of the committee, in our dialogue with states, does let many people fall through the cracks. And it sometimes doesn't allow for a clear discrimination, clear definition of what is direct discrimination, of what is indirect discrimination. So if you look at your law 2009, would you be able to say that is in full compliance with Article 2.2 of the Covenant that lists all the grounds for discrimination? And also whether you're familiar with the general comment of the committee, it's general comment number 20 on non-discrimination and economic, social and cultural rights. We have added 2 new grounds for discrimination based on our experience, that is sexual orientation, gender identity, and social and economic situation. If you would be willing to look at also those 2 grounds as an important contribution to a framework law on anti-discrimination. Thank you, Chair.
Thank you very much, Madam Bras Gomez. I have been informed by our rapporteur that she will not intervene at this stage, because I have to explain that the rapporteur has always the right to intervene if the rapporteur recognizes that it's needed. Therefore, we are moving immediately to the cluster 2, and under cluster 2, the first speaker will be Mr. Ribeiro Leão, and the next speaker will be Mr. Scriver.
Muchas gracias, señor.
Thank you very much, Chairman. At the outset, I would like to express a warm welcome to the distinguished delegation of the Czech Republic. I'd like to highlight the quality of the report, its annexes, and the data provided. This has made possible an open and constructive dialogue today. Along these lines, under Article 7 of our Covenant pertaining to health and safety in the workplace, under paragraphs 142 and 143 of the second report of the State Party, I would like to highlight that in paragraph 142, it states that protection of health and safety in the workplace is governed by various legal rules, various laws, and aiming to protect the health and safety. And I would like to know if there are any other type of conditions, or if you can give us any examples of the effectiveness of these rules and their practical application. I was also struck by paragraph 143, as I say, of your second report, which deals with reasonable governance of working hours. However, this would seem too mathematical for a lawyer, in particular a lawyer from South America, where I'm from. So I'd ask whether the distinguished delegation would be able to better explain the average hours, working hours per working day. I'd like to hear this from you. Thank you.
Thank you very much. Mr. Scriver will take the floor now, and he will be followed by Madam Shin. Mr. Scriver, the floor is yours.
Thank you. I would like to ask the delegation a couple of questions with respect to the rights to work. As so many other countries, also your country is faced with unemployment. It was very interesting to read, especially through the replies to the list of issues and detailed in the annexes to it about your active, what you call pro-employment policy. However, if I read the statistics correctly, you are still faced with quite a number of challenges in this regard. So I have some general questions on unemployment and the successes and perhaps also the failures of your active pro-employment policy. First of all, I noted that there is a very low rate of employment for women in the crucial age between 50 of age. Secondly, I also noted that there is considerable youth unemployment, and if I see the statistics correctly in Annex 6, it is increasing rather than decreasing, despite your policy to counter this trend. So, do I see that correctly? And if so, what are the reasons behind it? Could it be that the austerity measures have indeed a significant negative impact on the employment rate, or are there other factors? And to what extent do you feel that based upon the right to work and other labour rights included in our covenant, there is reason to revise your policies in this regard? Are there opportunities to do so, or are you faced by several constraints in this regard? Thank you very much.
Thank you very much, Mr. Scriver. Now I would like to ask Madam Sheen to take the floor, and the next speaker will be Madam Brash-Gomez. Madam Sheen.
Thank you, Mr. Chair. In continuation what my colleague has just raised about the considerable gap between men's employment rate and women's employment rate, there is also a gap, as you, Madam Head of Delegation, mentioned. There's gender pay gap, and also horizontal and vertical occupational segregation. And I think in order to fight against or reduce these gaps between men's economic activities and women's economic activities, there should be at least two systems. One is to fight against the gender role stereotypes, as well as developing a system of equal pay for work of equal value because of the horizontal job segregation. So my question is, what are the measures that you change the gender role stereotypes? And I believe you have a very generous maternity leave of 6 months. I would envy women in Czech Republic of having 6 months. But what about men's participation in child rearing? Parental leave or participation of men in childcare. Do you have a system to calculate equal pay for work of equal value? Otherwise, the pay gap and this gap between women's and men's labor force activities will be, continued. So those are my questions. Thank you very much.
Thank you very much, Madam Sheen. And now I would like to ask Madam Brash-Gomez to take the floor.
Thank you, Chair. When you read of the situation of employment and unemployment in the Czech Republic, I think the year 2012 was a difficult year for you because you have this, the new Labour Code that came into force. You also have a new Employment Act. And I'm concerned in relation to some of these measures which have affected many European countries, but I'm not quite sure of the results of these measures. My first question is in relation to the increased flexibility of labour relations to increase motivation of employers. This is a general trend in our countries. We had this EU concept of flexi-security, which was supposed to be flexible employment policies, but stronger social security. In practice, that has not happened. And therefore, my first question to you is, by putting into place all those measures to increase flexibility of labour relations, what was the result in terms of increase of employment, new workplaces created? What was the result of this flexibility? In relation to the Employment Act, it would also seem that it had a negative impact on the employment of many specific groups, including young people, because many groups that belong to an exhaustive list of groups who had increased protection, in the labour market are no longer entitled to that special protection, and that has also affected young people. And I would also like to hear your assessment on this issue. In relation to the minimum wage, I think the head of the delegation said that there was now the intention following in the coming years to update the minimum wage and index it to the cost of living. I'm not sure how it stands presently, because you haven't had a rise since 2007, if my information is correct. Now, in relation to the social security issues and under Article 9, I'm glad that you've referred to the letter of the chairperson of the committee in relation to the pensions, when you talk of the pension adjustment. You also tell us that after 2013, I think, or after 2014, you will go back to the original rules. And I want to check if the original rules are really the original rules, in the sense that it was 100% of inflation and 33% of the real wage growth. Are you planning to go back to those original rules, or are they different rules? It seems you've cut down on the benefits, which is also a general trend in the EU countries. Sickness benefit you've cut, reduced it to 60%. Well, I just also wanted to know if, in your assessment, if this has not weakened protection against the risk of sickness. I mean, it's all very well to cut, but till what degree is it acceptable to cut in order to be in line with covenant provisions? That is, of course, the decision of the state, but it is our role also to assess up to what extent that is in line with the covenant obligations. But what I'm most concerned about are the austerity cuts in relation to the non-contributory system, because that, as we all know, is the safety net. It is for people who are not entitled to other benefits based on contributions. And therefore, when the cuts reach the non-contributory system, and the explanations of the abuse of the system and people who are not entitled to it and are still getting it, well, I don't think that's really a big issue. I wonder how much abuse there really is in relation to the non-contributory system. And what is more of a greater concern to us is that it seems that you have shifted from a human rights-based approach, again, to a material needs approach, which is not always in line with the human rights-based approach. So generally, that is our biggest concern in terms of the cuts. And I would like very much to hear your assessment on these issues. Thank you.
Thank you very much, Madam Brash-Gomez. Mr. Sadi, no? I just misinterpreted your hand. It's okay. So in this way, ladies and gentlemen, we have finished the list of speakers under the Cluster 1 and Cluster 2. And as we agreed with the distinguished head of the delegation, we will now adjourn the meeting for 15 minutes. It is okay. So this means that we will reconvene our meeting at 11:20. The meeting is adjourned.